You're listening to 24/7 World Radio.
Broadcast today on January 2nd, 2023. We continue on now with the Jesuit attack on the old American common law, and then ultimately its imposition of the new common law, the new federal common law, that's continually being made by judge-made decision, which is internationalist, it's wicked, it's unlimited in powers, and completely contrary to a historic Bible-based white Protestant and Baptist nation that imposed a limited jurisdiction in the federal district courts. And common law would recognize God-given rights, whereas Roman civil law, which is followed by the Admiralty jurisprudence, does not exercise or acknowledge God-given rights. There's no such thing as God-given rights acknowledged on the high seas of commerce or in war. Okay, going on. So now the purpose of the second hour is to show you that there are two types of federal common law. And I wrote this up a couple days ago. If you want a copy of this, I will send it to you. And it's 10 pages long. An individual sent me a certain case, a certain paper titled "The Clearfield Compromise: Revisited Federal Common Law Post-Erie and Contemporary Preemption Issues for the Intimately Involved Sovereign" by Brandon W. Clark. And I don't have a date for this, but it's a most excellent 31-page document describing the federal common law post-Erie. There is a federal common law pre-Erie, which I have said has been abolished. And I was correct in stating that and teaching that. But I should have contrasted it with the new federal common law created by the courts after Erie, which is evil, which is satanic. The old common law is good, it is biblical, it is Christ glorifying, punishes crime. It has specific limitations on it, whereas the new federal common law really has no limitations except the decisions of certain men, which is evil. Okay, page 1 here now. I'm going to read this to you, and as I said, if you want this, I will send it to you. And I'm going to be adding this to my advanced class for clarification of matters, because I'm going to be teaching moot court in my advanced class, and you have to know this to successfully shut down in personam jurisdiction of a federal court if the judge is going to do his job and uphold his oath to the Constitution, as has been taught by Jack and Margie Flynn for the last 40 years. Thank God for those two dear people, those two dear white people that devoted their lives to showing what has been done in these courts. And by the way, they're getting older now. If you want a copy of their affidavit, you need to contact them, because I don't know how much longer they're going to be doing this. So, facts concerning federal common law. There are two types of federal common law. One, now I'm going to describe this first kind of federal common law, but it's going to be a historical description as well as what it is, okay? So, number one, there is an old federal general common law that was followed within the federal courts, Article 3, quote unquote, at law jurisdiction. That is a fact. To deny it is to deny the fact. A, that jurisdiction was exercised within a civilian due process of law. It followed English common law jurisprudence that had been developed within the American British colonies until the colonies became, quote, free, independent, and sovereign, unquote. Those are the words we find in the Dred Scott decision of 1856, when the colonies became free, independent, and sovereign, 1857, with the white Anglo-Saxon Protestant Declaration of Independence in 1776. So the old federal common law had a civilian due process of law in the federal courts. B, that English common law jurisprudence of the colonies became the American common law jurisprudence of the 13 states. The state courts followed their at-law, quote, civilian due process of law. Chancellor Kent is clear on this as explained in his Kent's Commentaries, an American version of the English Blackstone's Commentaries. The Pennsylvania version is Sharswood Blackstone's Commentaries. C. We the people improved the Articles of Confederation by creating the Constitution of the United States of America. That document would have 7 articles. We the people would delegate our sovereign judicial power in Article 3 of that Constitution, vesting that power with the Supreme Court. Article 3 also gave the power to Congress to create inferior federal courts that would also exercise the Supreme Court's Article 3 judicial power. This was done when Congress would pass the Judiciary Act of 1789, creating the district courts and the circuit courts. Even though they're creations of the Congress, these courts still had Article 3 judicial power and could proceed at law, in equity, and in admiralty maritime, particularly the district courts. D. The inferior federal courts exercising Article 3 judicial power would have 3 jurisdictions. They were, quote, in law, and I add historic common law jurisprudence, unquote, quote, in equity, and I add following historic equity jurisprudence, unquote, and, quote, of admiralty and maritime jurisdiction, following historic admiralty jurisprudence, unquote. These distinct jurisdictions were separate and had to be specifically invoked by the plaintiff petitioner in the federal district court having original jurisdiction. Each jurisdiction had its own specific rules of procedure to follow. They were at-law rules, quote-unquote at-law rules, quote, equity, unquote, rules, and, quote, admiralty maritime rules. So there were 3 separate sets of rules, depending on the jurisdiction that the individual invoked when he would bring his case. There was no merging of these rules until September 16th, 1938. Continuing. F, page 2. Over the years, from the Judiciary Act of 1789 to the Supreme Court's unanimous decision of Swift versus Tyson in 1842, remember that was a unanimous decision. The decision delivered by the great Supreme Court Justice Joseph Story, a, quote, federal general common law, unquote, developed within the civilian due process, Article 3, quote, unquote, at-law jurisdiction of the district courts. Because in Swift, they were sitting in a diversity jurisdiction, but it was still at law. And in the context of that at law procedure, they talk about federal general, this talked about a general law or a common law of the federal courts, which is described as federal general common law in the Erie decision that they abolished. Okay, so you see this federal general common law in 1842 was within the context of civilian due process. It was not within the context of any military due process as it is today, as we have today in the federal courts. Hence, if you're going to have emergency war powers military due process, you have to have another kind of federal common law. The old one's abolished because the civilian due process is abolished. I learned that the hard way. I learned that when I brought a 26 U.S.C. 7609 case, Internal Revenue petition to the federal court in Allentown, Pennsylvania, and I was before Judge James Noel Gardner. And when I pled to him that I have the common law right to work and exchange my right to work for money, he said, "Okay, Mr. Phelps," he says, "I'll make my decision. I'll be back." We waited. The opposing attorney was a Jewish gentleman named Ben Weir out of Washington. Kind of like the guy. And we waited for over an hour. And finally, Judge Gardner comes out, and I raised my hand and said, "Judge, may I address the court?" He says, "Yes, you may." I said, "Well, the opposing attorney here, Mr. Weir, needs to catch a plane within an hour here. And, we can just forego you reading the case, reading your decision, and I'll take it from there." He said, "Well, that's very nice of you, Mr. Phelps." He says, "However, I'm going to read this into the record." He said, okay. And Ben Weir said, that's okay, Mr. Phelps, I can get another plane. That's what I went through in the court of Allentown. And that Allentown Federal District Court is named after Judge Kahn. Judge Kahn is the judge that my teachers went before in Pittsburgh, invoking the Admiralty. My teachers being Lee Bropes and Leon Leshane back then. But Leah is deceased, Leon still lives. Continuing now is paragraph H. The Article 3 judicial power of the district courts was limited to 3 separate jurisdictions with 3 separate sets of rules of procedure. The district courts could see the real man or woman unclothed with a legal fiction. That's why they captioned the case in upper and lower case letters then. They never caption a case in upper and lowercase letters today. It's all an uppercase name because the uppercase name is a legal fiction deemed your principle for which you're surety. And they will never, ever upper and lowercase your name in a caption in any federal district court because I've tried about 6 or 7 times. They won't do it because they can't. They can't give any common law procedures. It's only emergency war powers, military jurisdiction, and hence within the new rules of the federal rules of civil procedure, which follows equity. There's lots of equity there, but it's a merged equity, merged common law procedures, and merged admiralty procedures, what they don't talk about. In an admiralty case, they're going to use all capital letters in an admiralty jurisprudence. A military jurisdiction is all capital letters, and it's going to follow admiralty jurisprudence. And in every military case, by the way, you check out the Carlisle College of War down there. You check out how they have captions in their cases. It's all uppercase. And why wouldn't it be? They're flying military colors. It's a military jurisdiction. And in a military jurisdiction, there's no place for civilian common law or civilian equity or civilian admiralty. Going on. 11. Oh, we read here going on. The district courts could see the real man or woman unclothed with the legal fiction. The district courts sitting at law, quote unquote, i.e. American common law. Who says so? Joseph Story in his commentaries on the Constitution, probably the 2nd or 3rd greatest Supreme Court justice who ever lived, could also see and uphold the common law rights of citizens, including the right to a civilian due process of law pursuant to a great Supreme Court case called Hale versus Hinkle in 1906, that the citizen of 1906, which is the pre-March 9th private citizen, has a right to due process of law, which is a civilian due process of law. Hale versus Hinkle. H. Satan is ubiquitous. That means it's everywhere. Counter-Reformation Society of Jesus hated this limited Protestant constitutional republic of the United States of America. This hatred would include the limited Article 3 judicial power of the Article 3 district courts, including its historic common law jurisdiction. Hence, a plot was designed to, number 1, remember, every Jesuit university is a military fortress. That's what Greisinger tells us in his great work, History of Jesuits is Told to the German People. He wrote it in 1872. You need to read it. He says every Jesuit university is a military fortress. That's where they're constantly conspiring against the liberty of that country. And if it's white Protestant and Baptist, we're conspiring against his constitution. We're conspiring against his people. We're conspiring against his rights. And by the way, there's a book written similar to that topic called A Foreign Conspiracy Against the Liberties of the United States, written by the great white Protestant Samuel Morse and the inventor of Morse code. Get it. Read it. Talks about the Jesuit conspiracy to overthrow our liberties. And one of our liberties is premised upon our right to a civilian due process of law. Morse wrote that in 1835. Chineke said in his 50 years in the Church of Rome that Rome is in constant conspiracy against the nations. He wrote 50 years in 1886, while the Jesuits were busy plotting the overthrow of our beloved American common law and civilian due process in the federal district courts. So, hence, a plot was designed to, number 1, centralize power in Washington, D.C., accomplished with the declared ratification of the Socialist Communist Jacobin Radical Red Black Republicans' 14th Amendment in 1868. Remember, there was not enough states who ratified that. So it was declared ratified by that criminal, Seward, the Secretary of State. 2, create a government for the District of Columbia, making it a, quote, Rome on the Potomac, unquote, accomplished with the District of Columbia, quote, unquote, Act, District of Columbia Act of 1871, quote, unquote. So the District of Columbia Act of 1871 gave a government to Washington, actually District of Columbia. District of Columbia had already been incorporated in 1820. But they're going to give it a government now in 1871 because they're patterning everything after the Vatican Empire, because they're going to make America into an American empire patterned after the Vatican here in the West, for the purpose of waging war against all the nations of the world to revert them back to the temporal power of the Pope. And that's the history of the 20th century. That's why Nada Molta Al Pacino said in that horrible, terrible movie, The Devil's Advocate, he said towards the end of the movie, who can deny that the 20th century was all mine, all of it? Who would write those lines? Why, the Jesuits who run Hollywood, using their certain token Jews. Continuing on. 3, do away with the circuit courts, centralizing jurisdictional power in the district courts, accomplished by the, quote, Judicial Code of 1911, unquote. So they're going to change the makeup of the courts. You can do away with the circuit court. And number 4, create the circuit courts of appeals, giving them only appellate civilian jurisdiction with the Judiciary Act of 1891. So now the circuit courts of appeals are going to have this appellate jurisdiction. And that act was in 1891. So that the circuit courts could never have an original act brought into their courts, as was the circuit courts. The circuit courts of appeals can never have an original action brought. Only the district courts can now. But back then, before, the circuit courts could entertain an original action, and it was generally in equity. Going on. 5, bring the admiralty jurisdiction inland to the disruption of the American common law as was done in England by Charles I. This outrage in England was one of the points of the Great Remonstrance that provided the reasons for the Puritan Revolution from 1642 to 1651. This is nothing new, bringing the admiralty inland. And that's what they would do in 1938. But they won't call it an admiralty jurisdiction. It's going to be a military jurisdiction proceeding according to the mode and course of admiralty jurisprudence, hence bringing admiralty inland. 6, page 3. Oust, quote unquote, the civilian government of the United States by imposing an emergency war powers military government. To do so, the Jesuit order would involve the Republic in a foreign European war. In a foreign European war, World War I, during which the Congress would pass its, quote, Trading with the Enemy Act, unquote, of October 6, 1917. Remember, when this country was brought into World War I, it was a violation of the Monroe Doctrine. And the Jesuit orders, filthy sinner Woodrow Wilson, advised by a 4th degree Knight of Columbus, Joseph P. Tumulty, overseen by his master, James Cardinal Gibbons, the Archbishop out of Baltimore, they would make sure that this country entered into World War I, which we had no right to do. And in the context of entering the World War I, the great grand design was pass the Trading with the Enemy Act in October and never repeal it after the war, and fashion it and amend it 14 times from 1918 to 1930. So by 1933, they're going to amend it the 15th time with the Emergency Banking Relief Act. And it will provide the basis, Trading with the Enemy Act will provide the basis for the proclamations of FDR and the basis for the Emergency Banking Relief Act. And hence now we would be under emergency war powers military government and the jurisdiction of the Trading with the Enemy Act, which would be an emergency war powers military jurisdiction. The Jesuits planned things 100 years ahead of time, and they planned their work and they worked their plan. Continuing on. It would be later amended, Training with the Enemy Act would later be amended with the Emergency Banking Relief Act, March 9, 1933, approving and confirming, quote unquote, the establishment of said emergency war powers military government. This would transpire March 9, 1933. And number 7, once the limited civilian government was ousted and replaced with an unlimited emergency war powers military government in 1933, to then abolish federal general common law, unquote, practice and procedure. Remember, they're going to abolish the procedure. That's why they got to merge the rules of federal procedure 5 months later in September, when they abolished this with Erie in 1938. So they're going to abolish federal general common law practice and procedure that would include, quote, civilian due process of law, unquote, via the Jesuitical Erie decision of April 25th, 1938. And 8, the Erie decision would overturn the nationalist Swift versus Tyson of 1842. In a footnote of this particular treatise or note that the author calls, he tells you that Swift versus Tyson was a nationalist decision. Of course it was. Erie will overthrow that nationalist decision and impose an internationalist decision called the Erie Doctrine. Because to have world government, we have to get rid of Tyson. Swift versus Tyson. And it's common law that it protected. The American common law jurisprudence, we have to get rid of that. Continuing. Paragraph 8, the Erie decision would overturn the nationalist Swift versus Tyson 1842 decision as promoted for many years by internationalist leftist jurists, including the socialist, quote unquote, Yankee lawyer. There's a book called Yankee Lawyer, and he was Supreme Court Justice Oliver Wendell Holmes, a Yankee soldier, very evil, very wicked, who wrote a tome, a huge volume on the common law that he secretly intended to overthrow. And dear brother Omar, my first Black American freeman, sent that book to me. Thank you, brother Omar. That he secretly intended to overthrow. And number 9, in the vacuum of abolishing civilian due process of law on a federal level, which included abolishing, quote, federal general common law, unquote, Section 17 of the Trading with the Enemy Act, TWIA, would immediately fill the void. So when you abolish federal general common law, which includes practice and procedure, there's a void that takes place. How are we going to proceed? Well, I know how we'll proceed. It's already in place for us with the Trading with the Enemy Act. We'll proceed under that Section 17. This is now codified at 50 United States Code 4316. It immediately filled the vacuum. With me? 10. Section 17, Trading with the Enemy Act, codified today at 50 U.S.C. 4316, would be the special war powers military jurisdiction conferred on the district courts for the enforcement of TWIA IBRA, Trading with the Enemy Act, Emergency Bank Relief Act. To make that happen, Section 5B of TWIA had to be amended to be brought inland, making every enemy, quote unquote, now defined as a quote unquote person, subject to this emergency war powers military jurisdiction that would proceed according to the course and mode of admiralty jurisprudence, bringing the admiralty inland. And you know what admiralty follows? Roman civil law. The Jesuits loved Roman civil law. They taught canon, the papacy, the priests, before the establishment of the Jesuits, the priests at the University of Bologna in Italy taught canon law and civil law, the civil law of Justinian, side by side. Because there's no God-given rights acknowledged in any of those bodies of jurisprudence. Admiralty follows Roman civil law. There's no common law rights. There's no God-given rights within an admiralty jurisprudence because you're not on the land. You only have God-given rights on the land. You don't have God-given rights on the sea. And admiralty follows the Jesuit order's beloved Roman civil law. And number 11, once the Jesuits had imposed their quasi-admiralty, quasi means like, quasi-admiralty due process of law on the district courts via TWIA, IBRA, and Erie, the Erie decision, they now could combine the rules of procedure for Article 3 at law, equity, and admiralty maritime jurisdiction into one set of rules, being the, quote, federal rules of civil procedure, and they did it on September 16th, 1938. See the flow here? Paragraph 12, page 4. Once the newly imposed Article 1 Emergency War Powers military jurisdiction of TWIA and the new rules of procedure for this jurisdiction imposed by the Roosevelt Supreme Court, a new federal common law, could and would be created by the Article 3 federal courts sitting in this Article 1, Section 8, Clause 11, Emergency War Powers military jurisdiction, proceeding according to the course of Admiralty Maritime jurisprudence. And by the way, in the tremendous Tidewater decision, I think it's 1946, 48, something like that, the Supreme Court states that an Article 3 court can sit in Article 1 jurisdiction. They've been doing that since 1938, boy. Treating us like boys. Conquered slaves, enemy belligerents. We can sit in Article 1 War Powers jurisdiction, boy, in our Article 3 courts. Tidewater even says so. Hold on. This would be done by a series of Supreme Court decisions, making the quote-unquote U.S. citizens, being TWIA enemies, deemed EBRA persons, enemies of persons, subject to the whims of federal judges and no longer subject to immovable, limited constitutional law protecting fundamental common law rights via a limited civilian due process of law common law procedure. No court can see common law rights. That's why Judge James Noel Gardner says, Mr. Phelps, you claim in common law rights here to work. You failed to state a claim upon which relief may be granted. Rule 12b6, boy. And so this court has no jurisdiction over your claim. So we're going to substantiate the IRS. You go ahead and give them their books and records. And the court was right. Because I did not know any of this back in, 2008 or so. 2. There is a new federal, so I've just finished describing to you the first federal common law jurisdiction. Now we're going to describe the new one. 2, there is a new federal common law imposed after the Erie decision and now crafted by the federal courts. Crafted. With Eric John Phelps back in a moment, 24/7 World Radio, concerning the Jesuit attack of our American common law and its replacement with the wicked papal common law of the federal courts.
This is the Eric John Phelps Show on 24/7 World Radio.
This is Brother Nicholas. Join me every Tuesday at 2 p.m. Eastern Standard Time for the German Bible Truth Hour and at 3 p.m. Eastern Standard Time for the Dutch Bible Truth Hour on 24/7 World Radio. This is Bruder Nicholas. Ich lade euch herzlich ein, mich anzuhören jeder Dienstag um 2 Uhr nachmittags, amerikanische Zeit, für die deutsche Bibelwahrheitsstunde und 3 Uhr amerikanische Standardzeit für die niederländische Bibelwahrheitsstunde am World Radio 24/7. Dit is broeder Nico. U bent hartelijk uitgenodigd om elke dinsdag om 2 uur Amerikaanse standaardtijd het Duitse Bijbelwaarheidsuur te volgen en 3 uur Amerikaanse standaardtijd het Nederlandse Bijbelwaarheidsuur te volgen op 24/7 World Radio.
This is 24/7 World Radio, and you're listening to The Eric John Phelps Show.
Historic federal general common law that included federal practice and procedure and jurisprudence of the old common law, done away with by Erie. And now we're covering the new federal common law imposed after Erie, called post-Erie. So, we read A on page 4. This new federal common law would be made by decisions of both the Supreme Court and the lower district courts. This new federal common law is not the old federal general common law of Swift versus Tyson, filed within the historic civilian due process of law. B, the district courts in making their decisions could include state law, including state common law, which would constitute the new federal common law within their emergency war powers military jurisdiction, proceeding according to the course of Admiralty jurisprudence. Proceeding according to the course of Admiralty jurisprudence. Add that little thing there. 3 Supreme Court decisions regarding this matter have already been addressed in a previous email because I'm sending this to my detractor. And so I addressed the 3 cases he gave to me, and I showed him that there is no federal general common law as it existed. But this common law that exists now can take its principles from state common law. It can take it from other jurisprudences. It's really unlimited what it can do, theoretically. Continuing. This new federal common law was and is being made after the Erie decision of 1938. The maxims of the old federal common law could be used within the emergency war powers military jurisdiction of the federal courts in the making of the new federal common law. And so they can draw from that. They can draw from those principles. They can draw from state principles of state law if they deem it necessary. You see, they're crafting a new federal common law, and it's not the old one. The old one was abolished according to the Supreme Court's Erie decision. Let's keep it clear. B or C. This new federal common law was and is being made after the Erie decision of 1938. The maximum of the old federal common law could be used within the emergency war powers military jurisdiction of the federal courts in making of the new federal common law. We read a few excerpts from the note, and that's what the author calls this. The note titled The Clearfield Compromise Revisited Federal Common Law Post-Erie, which is not the federal common law abolished by Erie, I will add, and contemporary preemption issues for the intimately involved, quote-unquote, sovereign by Brendan W. Clark. So I begin to quote some of the things that he says in his 31-page document. I believe it's 31 pages here. Yeah, it's 31. 36, 35, 36, 37, 38. Where is it? 39, 40, in his 40-page document. Okay, here I'm going to start quoting him here now. Paragraph 1, page 5. Quickly, however, the application of Erie in the federal courts demonstrated that the end of the, quote, federal general common law did not mean the end of federal common law. You see the two? There's the federal general common law that was abolished, but it didn't end a federal common law, because they're going to fashion and craft a new one. Federal common law constitutes, and I'm quoting him, federal common law continues to persist in many applications, most notably in the context of problems presented by federal common law preemption under Erie. This is page 2. He's distinguishing between the federal general common law that was ended by Erie and this other common law that will be created by the courts, and they can draw from the old common law principles, they can draw from other principles. 2, Charles Clark, the eminent scholar of Yale and the Second Circuit, observed that in Erie's wake, as after Erie, the federal courts were faced with immense questions of application and with 2 options when there was no state law clearly on point. They could, 1, with deference to Erie, attempt to discern how the state court would rule, in effect creating a sort of quasi-federal common law. That means like. Or 2, defer and stay the proceeding until such a time as an action, quote unquote, action for a declaratory ruling has been undertaken and concluded in the state court, unquote. That's page 12. So here they talk about, they have a decision. They can make a decision and in effect create a sort of a quasi-federal common law. This is not the old common law. They're creating a quasi-common law, a new federal common law. 3, beyond the 2 considerations Clark addresses, there is another which advances the next stage of the analysis. The federal court could act to create federal common law to the exclusion of any state law. So now they're going to be creating federal common law. This is a new federal common law created by the federal courts. This is not the old common law that was abolished by Erie. and I have a comment here. This is not the old federal common law within the context of civilian due process of law. This is a post-Erie, newly created federal common law, which I have never denied that it exists in the federal courts. When Erie ousted, quote, federal general common law, unquote, it simultaneously ousted civilian due process of law, which I will add include practice and procedure. That's why they had to have a new set of rules. They're doing away with the procedural rules of common law, and they're merging all of this equity, common law, and admiralty into one new set of rules for their new emergency war powers military jurisdiction, proceeding according to the course of admiralty, and they're going to craft a new federal common law within this military jurisdiction. Because the old federal general common law had no application. Excuse me, had no application in a military jurisdiction. It was only in a civilian due process at common law jurisdiction. Reread. When Erie ousted federal general common law, it simultaneously ousted civilian due process of law. It is this, quote, old federal general common law within the confines of Article 3, civilian due process of law, civilian due process at law procedure, which the Jesuits hate, that does not exist in any federal court since 1938. The author goes on, he states, page 13, the Supreme Court has recognized that the preemption of state law in favor of federal in the context of Erie is allowable but subject to great constraint and scrutiny. Indeed, the federal courts, quote, in the absence of legislation, unquote, are vested with the authority to fashion federal common law in cases raising issues of uniquely federal concern. Now they have the right to fashion federal common law after Erie, pardon me. Page 13. Page 6. That was page 13 of the author's work. Here's page 6 of my essay here, paragraph 5. Quote, that for purposes of this analysis is a form of Erie presumption. Even so, the Supreme Court has been clear that the instances, quote, where we have created federal common law are few and restricted, and has recognized explicitly that the vesting of authority to craft common law with respect to Erie, not apart from Erie, but with respect to Erie, that means post-Erie, generally depends on robust debate and clear communication to the federal courts from Congress to act. They're crafting common law, folks, after Erie. It's not the same common law before Erie. I add, the newly created federal common law is being crafted with respect to Erie. It is a new internationalist federal common law, not the old nationalist federal general common law, abolished by the Pope's Jewish Freemason and Jesuitical labor Zionists, Supreme Court Justice Louis Brandeis, delivering the opinion in Erie. Paragraph 6. Indeed, the difficulties inherent in the inquiry are clear, for very rarely does there inhere in the federal courts the clear authority to, quote, create a substantive federal general common law, unquote. Instead, the federal courts are routinely confronted in these preemption actions with a three-step inquiry. 1, whether there is some congressional grant of authority that explicitly empowers the court to develop federal common law on the subject. The Congress enable them to develop its common law. 2, if not, whether the interest presented is one that is uniquely federal interest or falls within the exceptions to traditional federal common law preemption under Erie, again related to Erie. Goes on, the interest is uniquely federal, whether there is a significant conflict between an identifiable, quote, federal policy or interest and the operation of state law, quote unquote, or the application of state law would, quote, frustrate specific objectives of federal legislation, unquote, page 15 and 16. 7, thus the court found that a variety of statutory constitutional sources afforded a sufficient basis for deference to federal common law, even if the right or duty itself did not expressly arise from a congressional grant of authority. So they can defer to the federal common law for the sufficient basis for deference to federal common law, but they were not under the old common law that had been abolished by Erie. They could take from principles from the old common law, but they're not under the common law of pre-Erie, which was civilian due process, practice, and procedure. 7. Thus, the court found that a variety of statutory and go on. 8. Texas Industries would be the bellwether that Clearfield needed to address the missing link of when an interest is quote unquote uniquely federal by going further than the court had previously gone and removing some, though not all, of the inherent subjectivity of preemption decisions in the federal judiciary. The court, after addressing the two sources of authority to fashion federal common law, outlined our 4 exceptions in clear terms. So there's subjectivity for the federal courts to fashion federal common law. That is not the common law that existed before Erie. And that's what I always said was abolished. He goes on, quote, federal common law exists only in such narrow areas as those concerned with the rights and obligations of the United States, interstate and international disputes implicating the conflicting rights of states or our relations with foreign nations and admiralty cases. So the federal common law exists only in such narrow areas. There's not a general federal common law that exists at law of Article 3. This is Article 1 federal common law that exists only in narrow areas concerning these matters of admiralty cases and others. I add, this new federal common law, fashioned with the subjectivity of the federal courts, is internationalist for, among other things, facilitating international commerce for the Pope's world government. That's the real reason behind Erie. Paragraph 9 of the note here by Brendan W. Clark. Quote, to be a sufficient sovereign interest, the issues at hand must be clearly defined, and a mere congruence or parallel reading of the statute cannot be enough to nudge a sovereign interest over the line to justify the selection of federal common law. It has to fall within a certain parameter in order to begin to impose a judgment-made federal common law. There's nothing absolute about this federal common law. There's nothing limiting about it. 10. The Fifth Circuit in Jackson, that's the case, has adopted one approach, rejecting an effort to define asbestos liability as a uniquely federal issue in declining to develop federal common law on the subject. Well, they didn't want to develop federal common law there, did they? They had the ability to. Go on, 11. I'm going to skip this because I'm kind of running late on time here and I got to finish. Well, yeah, I'll just continue. The court recognized that to be a sufficient predicate for the imposition of a federal substantive rule, an interest must relate to an articulated congressional policy or develop or directly implicate the authority and duties of the United States as a sovereign. So they're not going to develop federal common law in this instance. They had the ability to, but they were limited in doing it. 11. The Barani finding, that's the case, Barani, is all the more notable given in the Seventh Circuit went so far as to fashion federal common law on issues of quo warranto proceedings, despite the fact that there has been no significant general jurisdiction afforded to quo warranto proceedings in the federal courts. So, that case, they fashioned federal common law for quo warranto proceedings. The court reasoned that the federalized interests were, quote, require the limited availability of such a remedy under the federal common law of the federal credit unions, unquote. The Seventh Circuit's approach thus seems to be not really a question of sovereign interest at all, but more in line with the traditional field preemption view that legislative actions in a particular area can, in effect, preempt state law in an entire field. Here, absent express statutory authority to preempt, the Seventh Circuit elected to find, though not in name itself, a basis for federal common law under a theory that Congress preempted the field of issues relative to credit unions given their inherently federal dimensions. So, if the Congress is going to give statutory jurisdiction, if it's not going to do it, why the court will then create federal common law on the particular subject. This is not the old common law. 12, page 8 of my essay. The Supreme Court appears to have alluded, at least implicitly, under both precedent in Kimball Foods and Texas Industries, those are two cases, that the involvement of the United States alone, nor the fact that a decision may redound adversely to a federal agency, is sufficient to establish a federal interest for preemption purposes that can overcome the inherent preference against crafting federal common law. That can overcome the inherent preference against crafting federal common law. again, here he talks about crafting federal common law. It's being crafted by case decisions, especially the Supreme Court. Any understanding of Clearfield must always be, Clearfield is a classic case. If you've never read it, you need to read it. Any understanding of Clearfield must always be considered in light of the fact that the, quote, federal common law is, quote, subject to the paramount authority of Congress, unquote. That's this new federal common law. The old common law jurisprudence was never subject to the power of the Congress. It was completely within Article 3 judicial power, and the federal courts had every right to follow it and use its maxims in any decision that involved the common law. They didn't have to request permission from the Congress to exercise its at-law jurisdiction in consulting at-law jurisprudence good for 600-700 years. This is the new common law, new federal common law, not the old federal common law. Paragraph 13. However, Clearfield itself expressly contemplates that federal common law is to be resorted to only in the absence of an applicable act of Congress, when the authority then vests in the federal courts to fashion the governing rule of law according to their own standards. So they can call upon the old common law principles to fashion a governing rule within their new federal common law. But this is the new federal common law. It's not the old one with civilian due process. I add, the new federal common law is crafted, resorted to, fashioned, applied, expanded, and developed by the federal courts sitting in emergency war powers military jurisdiction. They rule for the benefit of the, quote, ship of state, unquote, pursuant to public policy. All is subjective. Nothing is in stone, as was the old federal general common law, quote unquote, followed within a civilian due process of law proceeding, which is practice and procedure, as per Article 3 at common law, or at law, meaning at common law, according to Joseph's story. Remember, we read that the first hour? At law means according to common law jurisprudence, according to story. This is why the Jesuit order had to make it go away with the criminal Erie decision, the question concerning abolishing, quote, federal general common law, unquote, having never been raised in the lower court, evidenced by the Erie dissent or dicta. The dissent of any Supreme Court case is called dicta, D-I-C-T-A. You read the dicta of Erie, and you will see that judge outraged, and he brings up the objection that this question of abolishing federal general common law, that question was never raised in the lower court, in the Court of Appeals or the district court. If it's not raised in the lower court, you can't come to the Supreme Court on an appeal. You have to raise the question in the court of original jurisdiction. So when they rule against you, you bring that question to the appellate court, then you bring it to the Supreme Court on a writ of certiorari. They didn't even raise the question in the original case, in the original jurisdiction. It was that's another reason the Erie decision is a criminal jurisdiction, a criminal decision. Going on. 14, paragraph 14 of my work. Quote, if any, or actually I'm quoting this gentleman in this paragraph 14. If anything, the decision to preempt and develop federal common law for unique federal interests requires a more nuanced approach that does not merely look to the Fifth Circuit's stricter emphasis on the United States as a party, nor is it confined to the total assessment of interest demanded by field preemption. In other words, if you're going to preempt the development of federal common law, you're going to have a more nuanced approach. But they're talking about developing federal common law. It's not the old one. Paragraph 15, page 9. Paragraph 9. Emphasizing, quote, emphasizing the federalized question as a condition precedent for federal common law affords an additional benefit. It provides the federal common law with a surer footing. That's this new federal common law, not the old one, because the old one's abolished. To avoid the charge that the courts craft common law beyond the scope of their Erie authority or invent new exceptions to the general rule. So they have the ability to craft common law, but they don't have the ability to craft common law, federal common law, if it's contrary to the Erie decision. Everything is based on that filthy, wicked, Jesuitical Erie decision that ought to be immediately repealed or overthrown by any decent Supreme Court. 16. This also avoids the hazard of suggesting that constitutional authority can be implied in the development by the inartful absence of a direct prohibition on the development of federal common law. Again, development of federal common law. It's being developed. It has limitations by which it may be developed, but it's being developed. Adopting this approach also embraces Justin Jackson's view in a much celebrated pre-Clearfield concurrence on the nature of applications of the federal common law. So now we're talking about development. We're talking about applications. Nothing absolute. This is Jackson's decision here. Quote, federal law is no juridical chameleon changing complexion to match that of each state wherein lawsuits happen to be commenced because of the accidents of service of process and of the application of the venue statutes. Venue means place where you're going to have the case. It is found in the federal constitution, statutes, or common law. Federal common law. Now, Jackson knew that the old common law had been abolished. So now he's going to talk a little more about it so there's no confusion. He said, federal common law implements the federal constitution and statutes and is conditioned by them. Within these, and that's just the new federal common law implements the federal constitution and statutes. It can only be the new federal common law because the old one is abolished. Jackson's writing this, and I think it's around in the 1940s. It's after 1938. Always, always, always look to the context of whomever you're quoting or reading. Reread. It is found in the federal constitution, statutes, or common law. Federal common law implements the federal constitution and statutes and is conditioned by them. Within these limits, federal courts are free to apply the traditional common law technique, not the jurisprudence, the technique of decision, and draw upon sources of the common law in cases such as the present, unquote. So they can draw upon sources, they can draw upon its techniques, but this new common law is not the old common law with civilian due process that was abolished by Erie. Jackson's redefining this new common law. And by the way, this Justice Jackson of the Supreme Court was another traitor, was another horrible conspiracy at the Nuremberg trials. He was there, and he did some proceeding against the Nazis on trial there. But Jackson was submitted to Jesuit Edmund Walsh, who oversaw everything that was going on at Nuremberg. And Walsh was in the uniform of an army colonel. And Jesuit Edmund Walsh ran this government in the 1940s, overseeing FDR. Being there with Proclamation 2039, 2040, Emergency Banking Relief Act. I further prove that in my course when you take it. Quote, Jackson's position that the federal common law is conditioned by the Constitution and statutes reflects again that the chief aim of an analysis of appropriate preemption demands a reliance on the statutes, or in other words, on Congress's purpose and intent. The Seventh Circuit's position, then, is to be preferred on many levels and would best realize the cautious approach to the application and expansion of federal common law. And that's this new federal common law post-Erie that has historically been adopted by the court in this area. You like that? You like this subjective new federal common law? Jesuits love it, because its power is only limited by the decisions of the Supreme Court. 17, quote, page 10. It is precisely this understanding that led the court to conclude in Atherton that, quote, when courts decide to fashion rules of federal common law, quote, the guiding principle is that a significant conflict between some federal policy or interest and the use of state law must first be specifically shown. They're fashioning rules limited by certain principles. 18. Paragraph 18, quote, it considers the contributions of both circuits, but makes plain that for preemption to be appropriate, the federal courts must strongly consider a determinative and actual intent of Congress and whether federal common law can be appropriately devised. It's devising it. When the federal courts are also severely bound to constrain its application in all but the narrowest and lucid of circumstances, page 39. And I conclude, this is yet more subjectivity within the new and ongoing fashioning of the Pope's, quote, new federal common law championed by Georgetown University Jesuits, including Viet Dim, above, who is the chief architect of the Wicked Patriot Act out of Georgetown, and he's a professor at Georgetown. The author in this work mentions Dim. So I give a conclusion, and the conclusion is, I will continue to teach the abolishment of the old federal general common law and its procedure and practice, as was happened through the Erie decision. And I will teach that there is a new federal general common law fashioned by the courts, which is for the benefit of the Jesuit order, the benefit for internationalism, and is evil and wicked, and that needs to be exposed. 2 federal general common laws, my friends, not just one. Back in a moment. Have a good day. I'll see you on Wednesday. This is Brother George. Lord bless. Bye-bye.